rights law. The victim the state was able to identify is a woman by the name of Julia Choice. It is my understanding that Attorney Rosenberg, on behalf of her client, has been in touch with Ms. Choice. She did know about today's date. She may appear according to Attorney Rosenberg, but the state did notify her of today's date. She was also aware and consented to the amendment of the criminal charge. So the state has complied with the victim's rights law. There has been no filings in terms of restitution in this case, but I am prepared.
All right, thank you. And Ms. Rosenberg?
Yes, we are prepared, and I can confirm that we have had contact with Ms. Choice this morning. She's aware of the courtroom that this is taking place in. I believe that she is attempting to make her way here.
All right, thank you. Then, Mr. Tiffin, if you could please restate the negotiations that were entered into at the time of the plea.
Yes, Mr. Choice entered pleas to an amended charge of second-degree reckless homicide and possession of a firearm by a felon. The state is recommending incarceration, leaving the length up to the court's discretion.
All right, and Ms. Rosenberg, is that a correct statement of the negotiations?
Yes, it is, with defense free to argue, of course.
Yes. And Mr. Choice, are those the negotiations that you agreed to? Thank you, Ms. Rosenberg. When you entered into your plea?
Yes.
All right. Thank you. Then, Mr. Tiffin, before that, I will advise the parties, the court has reviewed the sentencing memoranda and court report prepared by and submitted by the defense. Also included in that is a letter from Autumn, A-U-T-U-M-N Rush, and another from Ashantia, A-S-H-A-N-T-I-A, Choice, in support of the defendant. I also have previously received correspondence from Mr. Choice about his case that I kind of reread, and I have also re-reviewed the report that was received on February 17th with regard to Mr. Choice's mental health that was prepared by Dr. Collins. So we are also streaming this via YouTube. And I know that the DA's office further submitted a DVD which contained the custodial interview of Mr. Choice, and I did watch that as well previously. Okay.
Judge, in terms of, first, just in terms of a criminal record, Mr. Choice, for what I was able to check, has 3 prior convictions. One is in 2013 when he was convicted of operating a vehicle without owner's consent. The second 2, both were in the same case. He was convicted in February of 2019, possession of a firearm by a felon and possession of THC as a misdemeanor offense. With respect to both of those cases, sentence was imposed and he was placed on probation.
What were the imposed and stayed sentences?
The imposed and stayed time on the possession of firearm by a felon was 1 year at the House of Correction. The imposed and stayed time on the possession of THC was 30 days concurrent with the, they were both concurrent to each other. So those were his sentences.
All right, and the operating auto, that was a straight probation?
That was probation, correct.
Thank you.
So obviously when Mr. Choice committed this crime, he was on supervision, which in the state's view is an aggravating circumstance. Why it happened, I don't have a good answer. I know what happened prior to the homicide, that Mr. Choice Jr. was living with his sister Julia, with Julia's boyfriend, Mr. Choice's girlfriend, and their kids were also living in their house. Also, Mr. Choice's father, the victim in this case, was living here. That morning in August, there was an argument involving Mr. Choice Jr., his sister, involving something as benign as doing the dishes. And eventually, Julia Choice's boyfriend got involved, but that argument came to an end when Julia Choice, her boyfriend, left the home to take her to work. According to Mr. Choice's girlfriend, Ms. Menese, Meneese Perkins, Varick, her boyfriend, was upset after that. She had seen him earlier in the residence. She had seen him with a gun tucked into his waistband. And then she heard an argument involving her boyfriend and his father occurring in a bedroom. She then left the upper residence to take some clothes, I believe probably to go do laundry, down to the car. And while she was outside, she heard gunshots. She ran upstairs. Her boyfriend, the defendant, Mr. Choice Jr., said he was sorry, said he was an accident, didn't mean to do it. The police were called by residents of the lower unit, also called by Ms. Menese Perkins. The police arrive. They find Varick Choice Sr. sitting in the living room. He is surrounded in blood. He had 9 entrance wounds in his body. So he was shot numerous times. The only explanation or the only account of what happened was that of the defendant. He initially blamed an unknown person who had entered the house. No one ever believed that. And when the police told him that, and he then gave a statement that is summarized on page 3, that he was scared. He was scared of his father, and he just basically doesn't remember, but started firing a gun. That's the best I can tell the court of what happened, because that is what I know. There was a complete loss of control by Mr. Choice Jr. in terms of what happened that day. From the materials I read, I don't have a dispute or any basis to disagree with what Mr. Choice characterizes the life with his father. I know his father had contact with the criminal justice system. And while he was scared, the number of shots is just, it's sort of numbing in some ways. And it may be that he just wasn't aware, but he just started firing, and the gun kept firing. Mr. Choice, though, after it was done then, for reasons that I don't know, ran out. That gun was never recovered. I don't know what he did with it. He obviously should never have the gun tucked into his waistband like his girlfriend said. He told the police, Mr. Choice, that he picked it up from a kitchen, living room, by a living room window. He should never picked it up regardless. Even if he was scared, he could have left the residence. The nature of the crime in the state's view requires incarceration. Mr. Choice, from the material submitted on his behalf, has mental health issues. They will be mental health issues that will be with him for the rest of his life. But they did not provide an excuse for what he did here. He is responsible for his conduct, and one hopes those issues can be treated in the prison system. In addition, the community at this point in time, in the state's view, needs some protection from Mr. Choice, from his willingness to pick up a gun, or his inability to control his behavior, even if he was scared. This is a case in which the state views that prison is appropriate. The state's leaving the amount up to the court. The sad thing is, as a result, Julia Choice lost her father. Her brother will be out of her life, so to speak, for a while she can still have contact with him. So his actions have really ruptured that family unit that was going on in that case. But the state believes, given what happened, given the fact that he was on supervision for a felon in possession, given the number of shots, that prison's appropriate. The state is leaving the length of time on the 2 charges up to the court's discretion, and the question of whether they run consecutive to or concurrent with each other to the court's discretion.
All right, thank you. We talked about restitution briefly, I think, before the case was called. It's my understanding that there is no claim for restitution.
Right. Ms. Choice has never filed any documents or a claim or a request for restitution with the state.
All right, thank you. Okay, Ms. Rosenberg.
Thank you. I'm asking the court to consider sentencing Mr. Choice on this offense to 6 to 8 years of initial confinement, followed by 8 to 10 years of extended supervision. I'll start by saying that there is absolutely no question that the night of August 31st was an incredible tragedy. And I can tell the court that Mr. Choice has been coping with that and with his actions on that night ever since. The level of remorse at the onset, as well as throughout the pendency of this case, is significant. He knows the damage that he's caused to his family, to his children, to his siblings, to everyone that was there that witnessed this incident or witnessed the after effects. I met Mr. Choice for the first time back in 2019. I actually took him through intake court for his initial appearance. I had the unique opportunity to see Mr. Choice in what was clearly a manic state at that time. I saw the way that he was dealing with the demon inside of him that he had called Timothy. He was inconsolable. He was crying in my office. He was absolutely beside himself. There was fear in his eyes, which is strikingly different from the person that I see today. Of course, we know at that point, Mr. Choice was found not competent, but likely to regain, and he did regain his competency. There's also no dispute that Mr. Choice's history is riddled with abuse, a lack of stability, and significant but relatively new mental health issues. Mr. Choice watched his father struggle with his own mental health really all of his life. He recalls at his earliest memory, at about 5 to 6 years old, seeing his father angry, pacing, lashing out at him and his siblings when he was having manic episodes, and he would bear the brunt of his father's physical punishment at that point. He would shelter his other siblings and try to keep them from the physical abuse at the hands of his father. And he remembers his dad having bouts of stability when he was taking medication, and he remembers a completely different person when his father was medicated and not manic. But Varick never believed that he would follow suit, that he would follow in his father's footsteps here. Interestingly, just a few weeks, about a month before this incident occurred, he himself started experiencing symptoms of schizophrenia. And this is consistent with what we know about schizophrenia materializing in individuals' early 20s. Varick, though, like his father before him, thought that he could push through it, that he could handle it himself at the beginning. Obviously, that's not the case, but he remembers at this time pacing, becoming angry like his father had before. And then, when this individual in his head named Timothy showed up, everything really changed. A couple of weeks before this incident, Mr. Choice actually attempted suicide in early August. This was per Timothy's order in his head. Timothy would urge him to hurt himself and to hurt others, and he tried to push this feeling away. At night, he could feel Timothy actually physically kicking and punching him. Mr. Choice would hit his head against the wall, against the floor to try to get the voice out, and he couldn't stop it. At one point, he physically knocked himself unconscious just to try to relieve the pain of this voice in his head. He reached a point in mid to late August where he was unable to distinguish what was going on in his head between that and actual reality. So clearly we see the significant escalation once he became symptomatic. I won't reiterate the instability that he struggled with growing up. I know that the court has had an opportunity to read that in the memorandum. But I would like to iterate that, of course, at the onset of these symptoms, Mr. Choice, like so many others, had a lack of trust in the system, in his family, and his parents to come forward and talk about these new symptoms. Perhaps that's why he didn't seek help immediately. Clearly, the system failed him when he was young, when he was removed from his parents' care and placed back with his parents, shuffled between family members, continued to be physically abused. And trauma and vulnerability can, of course, play a significant role on brain development at that young age as well. Looking at the specific facts of August 31st, I don't think that there's much dispute. There isn't a great reason as to why Mr. Choice did what he did. What Varick does recall is that night, his father's mood changing, a tell that he was experiencing a manic episode. He also wants the court to know that while he was carrying a gun, at other times the gun was kept in a locked box in the closet on a top shelf. There were children living in this house, and it was important to all members of the household that this gun remained in a place that was unavailable to the children. It's not necessarily to mitigate the fact that he was a prohibited person and that he shouldn't have been in possession of this gun, but there was a conscientiousness of there being children in the house. He tells me that the only other person that had access to that locked box was his father, and that was scary to him. I'll also say that though Mr. Choice was not honest at the very onset when the police arrived, he was honest during the course of his interrogation. It's an incredibly difficult interrogation to watch. I know the courts had an opportunity to watch it too. It appears that he actually learned that his dad died, that his dad passed away during the course of that interrogation. Looking at Mr. Choice's criminal history, he has those 2 prior contacts with the criminal justice system, the Amvwalk. It was charged in 2012, just 2.5 weeks after his 17th birthday. He was eligible for expungement. He did successfully complete probation. The only part of probation that he did not successfully complete was the paying of court costs. So, but for his financial situation, we might not be having a conversation about the felon in possession here today. Because in 2018, the felony conviction was for the felon in possession based on that 2012 Amvwalk. I'll note that Mr. Choice has no prior history of violence. I don't believe that he has any allegations of prior physical abuse against any family members, friends, or otherwise. Looking specifically at the procedural history in this case, we all know that the restoration to competency for Mr. Choice didn't take particularly long. Unlike many that we see struggling with mental illness, Mr. Choice embraced the assistance. This is confirmed by notes from the WRC regarding his treatment to competency. And he's continued the entire time that he's been confined in the jail with mental health support as well as medication. This has been confirmed by WellPath records as recent as the past couple of months. And it's important to note this because he's not required to continue his medications while he's at the jail, but he did because he knows that this is something that's going to help him. And he has embraced that, and I think that that's important. Of course, the NGI in this case was not supported. There were 2 doctors that evaluated him, but both doctors recognized the significant role that Varick's mental health did play in his actions. Well, not to the level of the NGI. I think it's important to note that both doctors did recognize this. And in his months since his return to the criminal justice facility, there's been a stark difference in his demeanor. And I believe that that's based on his willingness to take his medication, his willingness to understand and take the time and the opportunity to recognize his mental illness and to treat his mental illness. Mr. Choice has an optimistic attitude that I think is incredibly important as we look at a case like this. And as tragic as this incident was, I don't think that Mr. Choice is somebody who's going to continue to come back into the criminal justice system. While it's certainly not an excuse for his behavior, I think that we have to remember that this was a man, Mr. Choice's father, who was physically abusive to Varick all of his life. That, combined with the early onset of delusional thought, I think it's reasonable to conclude that the chronic abuse from his dad, combined with the dangerous voices, became so intertwined in the midst of a manic episode that he was, at some level, unable to parse out what was in his head versus what was real. I think this lends some credibility to his another person theory and statement to police at the onset, because it was, at some level, another person inside of his head that was contributing to these actions. The criminal justice system in this case has clearly played a significant role, the intervention thus far, on Mr. Choice's mental health. This is a situation, justice system thus far, the intervention has done exactly what it's meant to do: removed Varick from the community and provided him with treatment. We've given him the tools to continue that treatment, and he's embraced that. He now knows the importance of his medication, the importance of understanding his mental illness and his mental health, and the importance of seeking help if these delusions return. Having spent 557 days so far already incarcerated since this incident, the only objective I think that we really need to continue talking about here today is punishment. And I think that we have to remember that Varick will live with his actions for every day for the rest of his life. I think that the goal here, what we as a community, as a system can do, is think about what we need to accomplish to help Varick stay on track, to continue to provide him with treatment, to help him transition successfully into the community from incarceration. I think that with Department of Corrections oversight and an understanding that any little transgression would lead to reincarceration will help deter him from reoffending, which is why I'm proposing that significant amount of extended supervision. This unbelievably tragic event is what caused Varick to have access, unfortunately, to the treatment that he needed. I believe that this timeout has given him the time to think about how best to be a father to his children, a brother to his siblings, and a participant of our community. Varick has a lot of goals that he's considered during the time that he's been incarcerated. And I'll let him speak to that more when he speaks to you after I'm done. But he's considered the things that he can do while he's incarcerated to help him when he is ultimately released. And I think that that's important. This is also a unique situation in that Varick's family is very supportive of him. We've had contact with many family members throughout the duration of this case, and they're supportive of Varick's treatment and, of course, of the amendment in this charge. And I don't believe, based on my contact with family members, that any family member is seeking extreme punishment, as we often see victims show up and tell us. 6 to 8 years in this situation would put Varick in his 30s when he's released. It's still a significant chunk of time. And the lengthy 8 to 10 years of extended supervision would put him well into his 40s by the time he's done with DOC supervision. It's enough time for him to continue some institutionalized treatment and develop a release plan. I'm asking the court to consider respectively to request a referral to the mental health unit for extended supervision. While I know the court can't order that, I think that that would be appropriate for Varick. I think that that would provide him with the resources when he is released. I think that this amount of time I'm asking to be concurrent to his revocation that he's already served. I think that this amount of time is enough to ensure that he continues to get that treatment while he's in custody, as well as develop that transition back into the community. I know that Varick has a couple of things that he'd like to tell the court as well.
All right, thank you. Mr. Choice, what would you like to say? I know it's difficult. You don't have to speak, but it's your right. And I want to hear what you have to say, but you have to speak up nice and loud right into the microphone, please. Thank you.
I just want to say I'm taking full ownership of what I've done. I know my father was a big picture in my nephew and my kids' life, and as well as my sisters and my uncles and uncles and aunties. I just want to apologize, deeply apologize to my kids, my nephew, my siblings, my auntie, and my uncles for what I've done. And I want them to know that I do have goals for while I'm incarcerated. My goal is to get my GED, take a college course for cosmetology or business, and come home and own a business for a barbershop. Just hopefully they can forgive me on one of these days. Thank you.
Okay, thank you. Just want to make a couple notes here. All right. These are very tragic offenses, obviously. Family, in the family offenses, homicides. And unfortunately, you're not the first. And this court has other matters pending involving siblings as well. When someone has experienced what you have experienced in your young life, it becomes especially important that they always remain vigilant. You know what that means? On guard all the time in your head, so that you don't hurt yourself or anybody else. And I know that apparently up until shortly before this happened, you weren't experiencing those kinds of behaviors, but you saw your dad and you saw how important it was when he was stable and perhaps taking medication, and you saw what happened when he didn't. And you took a lot as a child and a young person because of that. I'm sure your whole family endured a lot because of your dad's mental illness. No doubt. That doesn't mean that we don't love our parents, even though they're not the best parents ever in the world, right? We still love our parents. Most people do. And it's amazing to me how that stays the same. No matter what your parent has done to you, you still want your parent to be your parent and a good parent. And that doesn't go away no matter how old you are. So I understand that this is really difficult for your family and for you. But there are a lot of things, there are a lot of red flags here, and there are a lot of things that you could have done different before the beginning of your symptoms to avoid this. A huge thing is not keeping a firearm in the house. I don't care who had access to it and who didn't. I don't know if your father was a felon, but you certainly were. And you had already been convicted. And you were on supervision for the same offense. And it always blows me away that people don't take the simplest of steps to keep themselves out of jail. The simplest of steps. If you were afraid of your father using that firearm, and you did know, no doubt, that you were not to possess a firearm, the logical thing to do, the reasonable thing to do, the thoughtful thing to do would be to remove that box with the firearm. Even, you guys lived upstairs, right? Or did the whole family live up and down?
Upstairs.
Okay, and who lived downstairs? Relatives?
No, they were just
relatives.
a family,
Other tenants?
unrelated. Correct.
All right. But there had to be someplace else to take that firearm to safely store it, other than your house where you were living, where you knew you weren't to have a gun. And if you don't have the gun, the whole problem doesn't happen. That's the first step. The second step is to remove yourself from the situation, to better learn how to cope with what's going on around you, and to leave. Go for a walk. Leave the house. Instead, you chose to walk around your house during this very tense period with your dad with a loaded firearm in your waistband. Big problem. You know, and I've read we've gone over this before, I've read the report from Dr. Collins, I've read the sentencing memorandum. But there were things that you could have done, Mr. Choice, to avoid this, and to help yourself. And you chose not to. The court has to consider, when I sentence somebody, the need for the community to be protected. I have to consider what kind of a life you've been living. I have to consider what are your rehabilitative needs, meaning what can the system provide you with that will help you stay out of jail or prison in the future. You have a lot of needs. I have to consider the victims. This is obviously, it's a homicide. The victim's rights, the family is coming down for you, which is completely understandable. And it's tragic. I have to consider how to balance all of these things and a lot of other things, like your background, your experience in the criminal justice system, what the effect of this sentence will be on you and on others, in terms of what are we all learning from this. So it's a lot of things that the judge has to think about. And punishment is one of them. And the main one in your case for the court is rehabilitation. And second is protection of the community. You do have significant rehabilitative needs. The court does give you credit, and I'm going to speculate for a minute. I bet that the DA's office gave you credit as well for accepting responsibility. I know that you are sorry for this. They talk about that the word for that is remorse. Do you feel bad about what happened? Obviously, everybody knows that. I want to commend Mr. Tiffin, and I didn't write down his name, the job done by the detective that interviewed Mr. Choice. This was a textbook interview in terms of advisal of rights, appropriateness of the detective's behavior to Mr. Choice, and understanding the situation. So this law enforcement officer did an excellent job. And I'm sure, Mr. Choice, that I know from watching the video that this was very difficult for you. But I do give you credit on the sentence for being honest when the police questioned you on that video. And I do think that you will benefit greatly from rehabilitative services. And I do think that while you get those rehabilitative services, it will be important that the community be protected from you, so that while you are getting the help that you need, you will not be out in the community being supervised, because you've shown by your own behavior that there's too much of a risk. You were on supervision for having a gun, being a felon, and you committed a grave, serious offense with a gun. So for that, on count 2, I mean, that's pretty unavoidable what the sentence should be. What I'm going to do is tell you what all the terms and conditions of your supervision are going to be, and then I'll pronounce the sentence. The court is going to order that you pay all the costs and fees and surcharges associated with this case. You'll have to give a DNA sample, and that DNA sample will remain on file with the state of Wisconsin. You'll have to pay a surcharge for that. Restitution is set at 0. And I know Mr. Tiffin, we talked kind of around this. He's serving a revocation sentence. Is that finished, Mr. Tiffin or Ms. Rosenberg?
Yes, it is.
It's finished. And from the day that that sentence finished until today, how much time is he?
198 days from the day that his sentence was finished,
All right.
if my math is correct.
Agreed, Mr. Tiffin?
I will agree.
All right, the Department of Correction will certainly tell us if we're wrong. Because of the lifestyle that you were living, the court is going to order continuing vocational and educational training while you were in the institution, and you're to continue to participate in anything further that you want once you're released to extended supervision. Once you are released to extended supervision, you are to continue with any and all mental health counseling and treatment that the department orders. You are to continue with all medication during ES that the department orders. And throughout this sentence, you're to maintain absolute sobriety, Mr. Choice, from all illegal substances and from alcohol. And that includes marijuana if it is legal by the time you are released. Absolute sobriety. If you have a prescription, you have to tell your agent about it, tell them what it is before you go get it filled. So if you're taking something that the doctor says you should take, your agent needs to know. So your mental health meds, that's a must do. Alcohol, drugs, that's a must not do. You are to participate in a mental health evaluation and attend any treatment and counseling services that are offered through the institution, including any trauma therapy, childhood trauma therapy, etc. I'll refer you also to a parenting class. You have children, you had them very young. I am going to order that you cooperate with any medication orders that you are ordered to participate in the institution, as well as when you're released. And Ms. Rosenberg, I don't think I can order the CARS program, but I am going to strongly recommend it for Mr. Choice, the Community Access to Recovery Services Program. I believe I gave the felony admonishments at the time of the plea.
I believe so too.
Yes.
Okay, so we've gone through all of that, and the court sentence then will be as follows, and the credit will be awarded on count one in this case. As to count one, the court is going to order that you serve a total global sentence of 20 years, 12 years of initial confinement, and 8 years of extended supervision. As to count two, the court, because this is a second offense, committed so closely after the first conviction, because you were unsuccessful on supervision in the community, because of the number of shots fired and the ready accessibility of the firearm, despite your knowing that you were a convicted felon, Mr. Choice, the court is going to sentence you to the maximum, 5 years initial confinement and 5 years of extended supervision. And that sentence in count two will be served consecutive to count one. So you will serve a total of 17 years of initial confinement and 13 years of extended supervision. You'll file your notice of intent to pursue post-conviction relief, please. Ms. Rosenberg, is there anything further from the state?
No.
From the defense?
No, I don't believe so. I will file the notice of intent as well as a credit sheet by the end of the day.
Thank you. And I don't know what the department's policy is on these things, and it may change by the time he's eligible. But I am going to make Mr. Choice eligible for the substance abuse program and the challenge incarceration program as well. I don't know if, because it's a homicide, they may not take him, but I'll leave that to the department. I'll strongly encourage them to do so. Okay? If there's nothing further, then our case is concluded. Good luck to you, Mr. Choice.